don't ever scold me. Do you understand?
Totally.
Whoa, hey, sit down. I ain't sit down. Damn, you
No.
sit down.
Hey, look, yeah.
Sir,
Whatever they do with your
it's always an adventure here.
Telling you.
I don't know what's going on in there, but everybody wants to represent themselves now. They don't think much of the defense bar. What's all that about?
That's a back where.
We know. Mike started.
Well, there seems to be a,
At least I won't.
Yes. there seems to be a suspect identified by the defense bar.
I won't file all the motions.
I take full responsibility.
Good luck with a good deal now. All right. Who were you, sir?
Shannon on one.
Okay. 22-40911 is called. And what I have here, you were here and Mr. Reynolds is your attorney. You sent me something filed May 16th. That was 2 months ago. And I read this and you want to represent yourself, right?
That's correct.
Tell me why.
Well, I don't feel that, my constitutional rights are being,
You're what?
I don't believe that my constitutional rights are being respected.
Which ones?
Fourth Amendment, the Sixth
What,
Amendment.
tell me about the Fourth Amendment. What about that?
Well, first and foremost, I don't believe that had any probable cause for the warrant. We haven't,
The warrant, which warrant?
you heard it first, the murder charge. 22-40911.
You mean the warrant that was issued?
Probable cause affidavit.
Oh, okay. You know, notwithstanding the probable cause affidavit, a grand jury reviewed this and indicted you. That's the way they based it. Yeah, so just because you may have been arrested from an event, it was later. So this event was on October 7th, is what it says. But the grand jury in November reviewed it independently and elected to find probable cause existed. Plus, in the indictment, it's showing that you have 3 prior convictions, one in 2003, aggravated robbery, 2 assaults in 2012. The way this is worded, you are an habitual felon here. You're looking at no less than 25 up to life imprisonment years in prison. Do you understand? You understand?
No, I understand that. That's not what we're talking about.
I'm talking about it, and that's what we're going to do is what the court directs. Okay, we're going to talk about the issues that we have to deal with on the record.
Right.
And that first thing is, do you understand fully what you're facing here and what you're charged with?
Totally.
All right. Now, tell me about this Fourth Amendment issue.
Well, the Fourth Amendment issue that I'm speaking of is that, specifically the probable cause affidavit. What I'm saying that the affidavit didn't have any probable cause for arresting, which is not I'm challenging the veracity of the probable cause affidavit. I don't believe that he's a credible person to make the affidavit.
It's not
Okay,
a Fourth Amendment issue, Judge.
It's not.
It's not a Fourth Amendment issue.
Yeah, I let him talk.
Okay, let me read it. How about that? I'm not as well versed as y'all. I'll read it to you.
Read what? You have a waiver of counsel petition?
So that's what we're talking about again?
Yeah.
Okay.
Yeah.
So,
Yeah, I'm reading this. Okay, so
well, I was saying is
what is it? That's a legal issue. It
Right.
doesn't have anything to do with whether you want your lawyer to represent you or not. That's a legal issue that's been addressed. It's sent to me and I make the choice. I make the decision on legal issues,
Right.
not juries.
Right.
Juries decide facts.
Okay.
So let's talk about what it is, why you want, the issue is why you want to represent yourself and not have an attorney represent you.
Because I don't think I'm being afforded a meaningful opportunity to present a defense.
What is the defense?
What do you mean?
It's 4 words. What is the defense you're talking about? What is the defense? What is your defense? You're saying he's not going to present.
that someone else committed the crime. We have.
Oh, okay, well, that's what every trial is. Every trial is about who is the
Your
person
Honor,
who did it.
I wanna exercise my Sixth Amendment right to move forward pro se.
Okay. All right. You're gonna get to do that,
Thank you.
all right? And you don't ever scold me. Do you understand?
Totally.
All right. You can represent you. Generally, people fail in that regard, but some have been successful. And you certainly have experience. You have 3 felony convictions alleged here, so you know what the processes are. These 3 convictions, were these any of these trials?
No, Your Honor.
Those were all pleas?
Yes, they will.
How many trials have you had?
None, Your Honor.
You've never had a trial, okay. All right, so. You've thought about this long enough, and this is what you want to do, correct?
Yes, sir.
You're gonna get a chance to do that. And we'll set this for trial as soon as possible. You'll get to represent yourself. You have to realize that you have to follow the rules of evidence. You have to follow the rules of criminal procedure. You have to follow the rules of the penal code. The fact that you might be not be trained in that is not an excuse. Everybody has to meet the standards of those rules in a trial, or else you don't, in many ways, get what you were seeking accomplished.
Mhm.
But that's your choice. You understand?
I do.
All right.
Your Honor.
Then your wish will be granted. We will set this for trial. When can y'all be ready for trial?
Judge, we are ready. I will advise that we need to be specifically ordered to provide him discovery if he's going forward pro se. So I'd ask the court to go ahead and do that today so that we could start
It
making
is done.
copies.
Consider it done. I want this tried in 6 weeks.
That'd be fine.
Okay. That gets you quickly up here.
Uh,
Anything else?
Yes, sir. The discovery, will it be turned over to me so I can prepare for it?
That's what he just said he's gonna do.
Yeah, I didn't hear when I.
Yeah, that's what he's gonna do is, I want that as soon as possible. Okay.
Can I, well, on March the 13th, you also told him to turn over to discovery in 48 hours. That never was done.
Do that. Whatever you have, turn it
Well,
over to him. Make copies of it and then give it to him. Go ahead.
I gave him what he was entitled to under the discovery rule code of criminal procedure. I did not turn over my entire discovery file to him.
Well,
I
okay, what is
personally-
it?
I personally would prefer the DA do that.
Well, what is it that was a work product of yours, is what you're saying?
Well, it was things that are specifically excluded under code of criminal procedure that I cannot give to my client.
What he's referring to, Judge, is the statute that says that he can't give individual documents to the client. However, we've gone
You're
through this
gonna
before.
give it.
Right,
what
we
you've
will,
given
and-
to Mr. Reynolds, you're gonna give to him.
Correct. And what I'll advise the court
That's,
too is
that will be all.
we just dealt with this issue not long ago. The court specifically ordered that the documents be turned over, and that was sufficient to, get through that exception in the statute.
All
Can I, what exactly will be turned over? Could I know that specifically? I mean, I understand that, things that he's saying that I couldn't have are things that were covered under any kind of exculpatory evidence in Michael Morton Act, Timothy Cole, but yet he still told me I couldn't have.
right. You're gonna get that directly from him.
And what is that? Because he's saying that.
I don't know what it is, but I'm ordering both. I don't want to find out later that that wasn't done. But whatever you've received has come from the
Yes, sir.
prosecution. Whatever the prosecution has given you is ordered to be given directly to the defendant.
And that will be,
Okay,
There'll be a sheet that gives you a summary.
anything else? That is all. Okay, and let's be ready for trial. I don't want to lollygag on. Leave it.
sir, I don't want him as my second. I don't want him sitting on the side of me. I don't want any help from. this guy
You're not
whatsoever.
gonna, you won't need it. You'll be representing yourself. I'm talking to everybody here.
Thank you.
Is that clear?
Yes, sir.
All right, thank you. All right, Okay, what is your name, sir?
Johnson.
In 23 CR 2259. There's a motion for a bond reduction in your case. Go ahead. It's your motion.
If you could swear, then Judge.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand, Mr. Burbank, as his attorney. Go for it.
Yeah,
Thanks.
please, court.
Yeah.
For the record, what's your name? Mr. Johnson, you're currently charged with the offense of murder, is that correct?
Yes, sir.
And we're here asking that your bond be reduced from $250,000.
It is, how much now?
It is $250,000.
It is 200, $250,000 right now.
And prior to this incident, where were you working?
TDCJ.
And how long had you worked there?
2 months, 3 months, roughly.
Where were you born and raised?
Well,
Texas.
So-
hold on. You were working there. What were you doing there?
Correctional officer.
He was a correctional officer.
Okay, that's what I thought. Okay.
TDC. And so you've lived all your life in Baltimore.
Yes, sir.
And you have family in Baltimore?
Yes, sir.
And who do you have in Baltimore?
Mother, my father, and other several relatives.
Do you have brothers and sisters?
Yes, sir.
Okay, and they live there all your life?
Yes, sir.
You have tried to post a $250,000 bond, correct?
Sir.
At this time, you have sufficient assets in order to post, the bond. So you've asked your parents or your family to ask around and they have sufficient. If they're requested, correct?
Yes, sir.
And that's in excess of 25, 30.
This don't help.
Yes, sir.
Do you have any real property or any, retirements or anything that you can cash in or sell and what you get in funds?
Yes, sir.
In fact, you don't even have a vehicle.
Yes, sir.
Are you asking, so you have no assets at all to, post? You asking this court, to, reduce the bond to a reasonable amount so that, you may, post it pending.
Yes, sir.
Will you abide by all the rules and regulations, what may impose? For instance, it may be staying at a parent's house or of course, definitely within the jurisdiction of this court or this area, and other, type of regulations to be able to do correct.
Yes, sir.
And pass the witness, Judge.
Spain, any questions of the defendant?
You never denied being in the shooting, right?
Yes, sir.
Matter of fact, you were shooting at an individual that was stealing your car. Is that correct?
Yes, sir.
And then after the car wrecked, you went back inside your apartment and got a shotgun and came back out while the person was inside the car and shooting, right?
I'm gonna have to ask him not to, under oath to say anything. There's a probable cause affidavit there.
All right. I'm waiting for it.
Oh.
If she's getting it. I don't have it. It's not in the file.
So you're gonna advise him to take the fifth on the rest of this? You're not gonna let him testify the rest of this?
Well, we're going to trial.
Huh?
No, we're just talking about the hearing right now.
Yes, sir, just for this.
Do you want to ask any other questions or?
No, sir, if he's not gonna let him answer any more questions on that part.
Right, let's talk about the rules for setting bail. This is found under Article 17.15 of the Texas Code of Criminal Procedure. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense is an offense involving violence as defined by Article 17.03. The defendant has been indicted with the offense of murder, alleged to have occurred on or about July 30th, 2023. It is alleged shooting the victim with a firearm. And so, this is a first degree felony, which is a most serious offense. And this felony is also a crime of violence. what these multiple pages involve are not arrest warrant affidavits. These are search warrant affidavits, which they'll include information concerning the alleged offense. All right, essentially, this affidavit for search warrant seems to state that on July 30th, about a year ago, this happened last year, Beaumont Police respond to 6550 Phelan Boulevard in Beaumont in reference to a shooting and a deceased body of Xavier Massey was discovered in the driver's seat of a white 2017 Nissan Pathfinder. That was your vehicle? Yeah. And Massey had succumbed to multiple gunshot wounds according to this affidavit. And the vehicle showed extensive front end damage plus multiple bullet impacts along the driver's side of the vehicle. Officers found a trail of 9mm shell casings tracing back to a parking spot in front of a particular apartment at that location. The vehicle was registered to the defendant who resided there. And according to this affidavit, a witness or witnesses stated that they perceived that someone was attempting to steal the defendant's vehicle. And this is, looks like 10 o'clock in the morning. The defendant ran after the vehicle, yelled at the driver to stop. It did not. And the defendant started shooting at the car with a pistol he had. The car was wrecked. The defendant went back inside the apartment and retrieved a shotgun, approached the car, and began shooting at it with the shotgun. The defendant was interviewed. He declined to answer any questions without an attorney present. However, he volunteered one statement that he stated he was getting ready for work and someone was stealing his vehicle. Okay, so there are the details from the affidavit for a search warrant that was granted by a district judge concerning the facts of this case. Okay, so the nature of the offense and the circumstances under which the offense are committed are to be considered. And again, this offense, which was alleged to be murder in that it alleges by the grand jury that the defendant intentionally and knowingly caused the death of another with the use of a firearm. So it is an offense involving violence, a most serious offense, murder. So that is an aggravated factor in determining bond. Then the future safety of a victim of the alleged offense and law enforcement community shall be considered. Well, I don't think that's an issue here because the victim in this case or the complainant is deceased. Now, I don't, you've presented, there are other attributes and the defense has presented a succinct set of information for the court. But under court decisions, there are several other aspects which the court doesn't know anything about. It's ignorant to, and that's not my issue to address. I don't know anything about that. All I know really is statutorily that this involves a most serious offense of involving violence and some information concerning the background of the case. But other issues that the court can consider, it's not before the court. Nobody's submitted them, so I'm kind of in the dark on that. So what information I have is
What do you?
I can't do that. Those are
I mean, Judge,
factors of bond that's for y'all to present, not me to pull out.
we have that he's a lifelong resident. He worked for TDCJ. He has family members. Whoa, hey, Sheriff. I ain't said that. Man, you
No.
should, hey, look,
Sir,
whatever they do with your ass, I'll be
Sir.
working on your punk ass, you motherfucker. bitch.
he is arrested.
17-year-old little child, mother.
He is under arrest. He is directed to be arrested. He is directed to be arrested.
Want to do that anyway.
There shall be no outbursts allowed. There shall be no threatening of individual. That is a constitutional right violation. The peace and order of this court has been disobeyed, and that person is taken under arrest immediately.
Phone is on the floor. No. So now you're gonna on my phone.
Okay, who was that person? Does anybody
Father
know
of the
who
deceased.
he's what?
The father of the deceased.
The father deceased, okay. Well, too many cases in this court involve issues where family members are under stress and distress for losing a family member. We all understand that. Nonetheless, we try to deliberately move through proceedings in accordance with law, because the law is set to determine an outcome that is as just as it can be and as civilized as it can be. And outbursts like that have no place in getting to a managed completion of hearings or resolvements in matters which need to be deliberately and intelligently and based upon law accomplished. And this isn't a time for a lynching. And that's no place in this room for that sort of behavior. So now he's arrested. But we're going to get back to this hearing on determining what is appropriate here. And the court's obviously not going to consider. Well, we're listening to that person. You can hear the person who's still complaining about him being arrested for his actions, and obviously his decision to act outside the bounds of the law don't do anything to accomplish legal methods of deciding important issues. And let's just focus on this bond.
As I was, if I can continue, Your Honor.
You may.
I believe his criminal history is very limited.
What is it, if anything? Do we know?
Now he works in ECJ, so we know he passed background. He does have family ties, has lived here in Beaumont all his life. Has family here, substantial family. He's lost everything in reference to being incarcerated in reference to financially. The car at the time was just purchased, and he was anything. I don't think he has anything.
I don't show him criminal history, Judge.
I haven't criminal history. He was on payments, so he's lost that.
What are you asking for?
I'm asking for $100,000, Judge.
All right, state your response, please.
Judge, even though these are strange circumstances, the fact that he went back out after the crash occurred and shot this person while they were sitting in a car with a shotgun, I got a problem with that. I think the bond is sufficient the way it is. Or
Sir,
with another
if you
guy.
want to, if you want to talk to him, you need to talk to him discreetly. But if you want to make statements that I can hear, I'm going to take those into account. And this, once again, you're beginning to act like someone who makes outbursts like that. There are rules of decorum. If you want to take the stand under oath, you're entitled to. If you want to talk to him, you're entitled to. But if you speak to your attorney, it needs to be discreetly, not in a way that all of us can hear, because that's not discreet. That's no longer something that's protected under confidentiality rules when we can all hear what you're saying. Well, I don't know a lot about the defendant except his work record. But it begins here with, under the statute, the nature of the offense and the circumstances under which it are committed are to be considered. And right now, we're talking about
Oh, absolutely.
a crime that is involving an article of property, which is generally the second most expensive thing people have next to their home. So it has importance to people. And not only we just don't get around on horses anymore, but it's mobility, which is required to get to and from work and to and from food, to and from hospital care. So it has its importance. But what I'm reading here is a situation where when somebody is fleeing in the car, the question becomes, what can you do? And lethal force is not the answer when it's involving the theft of property.
I think that comes out during trial, Judge.
I think it will. I'm sure it will,
Yeah.
but right now, the goal is, of course, to get the property. So the property was disabled, right? Here at the scene.
Yes, sir.
And that's the problem, is what the state has addressed is I think the defense can do what they need to do to try to stop the theft from occurring. But once the theft has occurred, or once the piece of property is disabled, going back to get the shotgun and killing the guy was then an execution, which is not an option under law for the theft of property. It is not, that is not an option of punishment under the law.
Again, Judge, I think those are
Is
issues.
execution.
Right, I think that's what the court assumes, and I think it's an issue at the time
No,
of
no,
trial.
that's what happened though.
Well,
The car was disabled. He goes and gets a shotgun and then kills the person.
not necessarily, Judge. I can't,
Well, the person is dead, isn't the person deceased?
Yes, sir.
Was the person killed by the shotgun blast?
There's several bullet wounds to this individual from the back, the head and side. And I'm trying, it's not my case, but there were 2 shotgun shells out
Was
there.
anybody else
at the-
shooting at the person
No, sir.
other than this
No, sir,
defendant?
but there were 18 shots fired from the 9mm, and then there was 2
Okay.
shotgun shells out there at the end.
Okay. I think people have a right to try to stop the vehicle and
Under certain circumstances.
under
yes, sir.
circumstances,
Yes, sir.
but
The deadly
once the
weapon.
vehicle here, the court's finding is that the vehicle was disabled. And then after that is where the problem exists on his bond.
well,
I know you
Respectfully
disagree with
disagree
that, but that's
with
what my
that.
finding is what happens with the shotgun and the lethal force that was used after the car was disabled is contrary to what the law allows. And just like that man being arrested for his outbursts, which was against the law, this court is going to find that the way the defendant handled this, especially after he goes to get the shotgun when the car is disabled, is an aggravating factor that weighs against a bond reduction under this case. I find the bond to be reasonable in that here he goes and executes the person after the property had been disabled. And that's a different, put this into a different situation. I can appreciate him trying to stop the loss of something expensive like that. But it's what happened after the car was disabled. He was not getting his property back after that. He was taking revenge. And that does not weigh for his benefit. And I find that bond amounts are appropriate under these circumstances. Okay. What's the next event?
we've set September 16th.
Or,
Trial.
okay, done. Thank you.